He was here the other day.
Good afternoon, everybody. Welcome back to House General and Housing, and it's the 24th of February, 2026 today. So this afternoon, we're doing two things. One is we're starting to look hard at rental agreements and reform of rental agreements, landlord tenant agreements. And we're also going to take a look at H 887, which is an act relating to crime victim status under the Fair Employment Practices Act. And we'll be dealing with the landlord tenant issue for several days. What we've been doing is using H772 as a markup device. And we are taking pieces from other bills because there are a total of 6 bills that we've been considering, 5 of which are formally in our committee and one of which is across the hall in judiciary, but we know what's in the language. What people on the committee are familiar with 772 as it was originally introduced. This is a substantial second draft that is incorporating a lot of the suggestions made by various witnesses, including the Judge Zone and Terry Clifton, who raised a number of technical issues which are addressed in this draft. And a number of new thoughts. I've met with our council several times. We've gone over it, trying to remember issues that were raised. And so I think the best thing to do is just to ask our council to start walking us through this draft. This is a markup in the sense that this is a chance to talk to him to see if we can have consensus on additions, changes, or whatever he should undertake with this draft, and then come back tomorrow with a revised version. So rather than characterize it myself, I think I'm just going to ask you, Cameron, to identify yourself and take us through it.
Sir, good afternoon. Cameron Wood, Office of Legislative Counsel. What I've drafted, so as mentioned, we have an amendment. It's for H772. It's drafted as a strike all, draft 1.1. That's what I'm going to share my screen and start to walk through. Should be available on your website for those following along. A few things I will just mention right out of the gate. There are a few provisions that I'm still working through to either include or review for further amendment. Simply for a 30+ page bill, needed to get it to editing in time to be able to bring it to you today at 1. So at some point I had to stop making amendments to allow it to go through that process. For example, I still need to add in some language that was requested from the State Housing Authority. If you all recall, they have their own, federal regulations on their, termination periods, etc. So I don't have anything in there about that, but expected to include something to that effect. Still trying to work through some of the trespass language, which we'll get to, but I have incorporated the bill that was mentioned that's in judiciary, 728. And I'm still working through the confidential ejectment records section. I did strike some things based on, Mr. Chair, as you mentioned, recommendations from the judiciary, but I still want to go through that section kind of comprehensively and make sure it's buttoned up. So just at the outset, for those following online and for you all, just wanted to mention a few of those things. And just know that if you're looking, for example, in the confidential sections, hey, this doesn't make any sense. I'm still needing to kind of go through that with a fine-tooth comb.
Let's talk about that just for a minute. I'm just going to refresh everybody's memory. Judge Zone and Terry Clifton had a number of very specific, page by page edits. Most of which I think have been reflected in this draft, but also they were On the issue of the confidentiality provisions, they felt that they were filled with exemptions and that they were atypical in that regard, because there are other procedures that are confidential, but that this was more elaborate. There were exemptions, motions allowed, people who had access that went beyond the parties and their lawyers, et cetera. And so what I did is ask council to strike all of that, to try to make it simpler. And then also to take a look at the other statutes, where it's confidential, just and sort of compare and see how they look. So that's obviously a work in progress still.
Yes, sir.
All right.
And the other piece, for example, last piece I'll mention this, and then we're just going to get into the language. The appropriation to $600,000.
I sent you what we got, but
I just didn't have a chance to incorporate it. So, so if you have questions, feel free to stop me, where is this? Or, I thought we talked about that, because I'm happy to take notes and continue to work this through.
Also, this draft, I made some choices in this draft to include something for the committee to see how they felt about it, rather than not put it in, like the $600,000 appropriations. Also, you'll see in a minute, one of the concerns that was expressed in testimony was the whole problem of tenants being notified that a lease is over, or that the landlord is going to change the use of the building or something like that. And essentially finding a way to move in time. And we dealt with that in part by giving a long notice in those cases. But in addition, you'll see an attempt on my part to try to have a system whereby they can get some of their deposit back earlier than the end of their lease, assuming that they haven't messed up the apartment, and assuming the apartment's in good shape. You'll see that. That's the kind of thing where I just want to put it in front of everybody and see what your reactions. Okay.
Okay, so as mentioned, we have a strike all amendment of 772. This is draft 1.1. We're going to start walking through. There are a few different highlights. Just understand that where something is highlighted yellow, it's should be, for the most part, either an addition or a change to 772, or as discussed, something new, etc. If there's a few things that are highlighted blue, because I wanted to pause and have a conversation with you all about the policy piece of it. So that's kind of the reasoning behind those colors. So for starters, section 1, we're amending chapter 137, residential rental agreements. And if you all recall, we discussed this definition previously, actual notice. The changes that I've made since we first discussed was, there you can see on line 14, receipt of is back in. So initially that was struck. So this would require the individual to receive the notice, not just mail it. There is an obligation that the individual has to have received it. We've added, kept the delivered by sheriff's service. You have mailed to the last known address or the address provided in the residential rental agreement. That is the same from the bill that we've reviewed before. And then you have emailed to the email address included in the lease agreement and mailed as described. And I highlighted that blue simply because I wanted you all to know it's not necessary to have both. The presumption is the same of receipt for both. So it is a policy decision of you want to require, if you're going to email it, that you also mail it. Just understand that you could just mail it. You don't have to email it. So I just flagging it for you all as a policy discussion. The change in first error on my part, that sub 5 at the top of page 2 should be highlighted yellow. If the last known address is unknown, posted on the door of the dwelling unit. So that is the change based on the conversation that we had the last time we were together. And then I will add in the sub B, there is created a rebuttable presumption that the notice was received 5 days after. So the proposal here in this amendment is going from 3 to 5. And then added in that the rebuttable presumption exists the date the email was sent, if sent via electronic means. Or if the sending party proves that the notice was sent first class or certified mail, the date of the mailing. So the mailing presumption's already there. We're adding in the presumption for an email, changing it from 3 to 5, and then, Mr. Chair, I will comment, you made a question to me or posed a question to me. There is no presumption based on posting on the door. And that may be something that you all want to include because technically it requires receipt. And if you're posting it, arguably by definition, you know the person didn't receive it. So you may want to add that into the presumption that says the person is presumed to have received it 5 days after you post it to the door or a different period.
Joe, go ahead.
Yeah, mine would just be on 5 there. That seems kind of odd. Are we stating last known address just because it's used in law? Because it's not really a last known address if it's unknown.
So
Kind of a,
my recollection from the
Negative.
conversation you all had is, you know, you can't find the individual because they, you know, may not be around the apartment and you may not know what their last known address is.
so if you have no address for the person, just be kind
You
of,
could say if the address is unknown.
if the address is unknown. I mean,
I would probably keep it as last known. I mean,
I'm just curious if that's because it's used elsewhere in law as last known address and.
it's used there in the current statutory section of required the last known address.
Yeah.
I mean, you need to indicate what address are we referring to? Like if the address is unknown, what address is unknown?
Let's
So
go
that's
back
why
up
we
again.
Keep if their last.
What is the last known ad? It says. Where is it? Oh,
It's here under 3, it's mailed, so you have to.
But that
mail it
gives
to
you the
last
rebuttable.
known.
address. Or the
Or-
address, I see.
As
No,
was mentioned, they
that's not
could have a PO box, they could, you know,
It just kind of stuck out to me as like.
Okay, it's a little weird.
Maybe it's fine.
Isn't it, is the point not that the last known address is no longer current? Because they're gonna at least have an address on the rental agreement, that might be the last one got, but that's not their current mailing address. That's the point of posting on the door.
I'm not the one recommending it, so you might want to ask that question to individuals who work in this area. I know you have some on your committee who engage or are landlords. I think the thing here is if you don't know what their address is, I mean, I think intuitively their address should be the location that you're terminating the rental agreement for, but that doesn't necessarily, you know, I can't imagine a scenario where that's not always the case. But again, the person may have, you know, abandoned, or, you know, you could be one room within the place that you're trying.
There are tenants. There exist tenants. I can see where, you know, they don't have a mailing address, they don't have a PO box.
Right.
They just give you a telephone number or a.
And that was what I was gonna
Maybe,
say, is
yeah.
you're not required to give an address.
Yeah.
And a
So they may not. Let me step back for a minute. This is an important section. This is not just, you know, detail. The reason is that you really need to be able to give people notice. And also there is, in some cases, people try to evade notice. So what we're doing here in this section is saying you have to have received the notice, but it's not enough for a tenant to come in and just say, oh, I didn't get it. There's a rebuttable presumption means that it's just presumed you received it if, and there's the list of, you know, if you did any of these things, it's just assumed that you received it. What it does allow Oh, we increased it from 3 to 5 because of the mail, just because mail is so terrible these days. But the assumption that a tenant could come in and say, let's say you ended up posting it on the door, or you ended up sending a certified mail. It's presumed that they were notified. But they could come in and say, I can show you, I was traveling for the last month. I didn't get anything.
I was staying with my mom because she was really sick.
Yeah, or something like that.
I was in Florida for the winter. I never checked my mail.
Right,
I
but,
never checked my mail.
well,
I had somebody check in my mail and they were sending me what they thought looked important, but the postal system took a really long time to get it to me.
so the assumption, I'm sorry, go ahead.
Can I ask a question? Is 5 what we called a tack order?
Yes,
So would 5 change the fact that with a tack order, you need to get, doesn't the judge need to approve that?
If you're in
Court
the
process.
judicial context, yes. If you're pursuing a court case, yes, you have to comply with the rules of civil procedure. You would need permission from the judge.
But this is not that. This is outside. We haven't yet got to an eviction.
This is
Just notice that you have to give that you're
Okay, so
terminating.
there would- There would not need to be that. in
Yeah,
addition.
you don't have to get a tack order. And in fact, just so you know, I suggested to him, why don't we get rid of the tack orders? Why don't we just use the same definition of litigation? And he said to me, don't do that. So I,
Cameron said that?
yeah, I said, don't. do
This
that.
he?
Yeah, Cameron said, don't do that. And we'll get to why that is, but what we did put in the litigation context, it's from Debbie's bill, which says, once you get the tack order, it's there for the whole rest of the litigation. But here, the presumption is, if you do any of these things, you've notified them. I do think that that list should include the posting on the door. Yeah, the presumption, yes.
yeah. So my point was just that for that, it wasn't good or bad, it was just purely the wording of that sort of odd way. It to me, but I mean. That's the way it should be, because if we use last known address somewhere else, then. As long as it gets to the same point, I don't really too worried about it. The only other spot I was gonna point, just because they're so close, was the. Created the rebuttable presumption. It seems odd that you can mail it, then you're good, or as long as it's that. But the email has to be both, but then just below that, we say it doesn't have to be both. The email is a standalone below. As opposed to
Where is it
above,
standing
it's,
alone?
Well, they would be the same, so.
Irrebuttable.
Under the rebuttable presumption, so if you emailed it and mailed it, the individual, the presumption is gonna be 5 days from the date you mailed it or sent it. So if you email it and send it the same day, the presumption if they received it, the date would be the same. But I agree.
It's the 5, it's a little hard to read, but there's created a rebuttable presumption that the notice was received 5 days after the following. And either the date 5 days after the date the email was sent, or 5 days after the date of the mailing of the notice.
But I highlight because I will say it this way, I mean, if you're going to require both, this is a policy decision for you all, if you're going to require both. I don't know that you need both. What I mean by that is, unless you're wanting to ensure that the individual is getting the information in as many possible avenues. I don't think you need to have both.
I see.
Yeah. mail.
In other words, here's the question for y'all. Here's a list of notice, what notice is. hand delivered, delivered by the sheriff, mailed, or emailed. And the way this is written, email alone is not enough on the list. You can't just email. You have to email and mail. That's the way it's written. Yes,
Why can't it just say or?
It's a policy issue. If you want it to be one, is just as good as the other. But Mark is saying, just email alone is not good enough. It should be emailed and mailed.
I'm actually not taking sides. I'm just saying.
But the way it's written, that's.
Yeah, the way it's written is that notice consists of any one of the following. Hand delivered, delivered by sheriff, email, mailed to the last known address, or emailed and mailed. In other words, it's an and. So I guess out of.
What's the committee's pleasure?
Yeah, the thing was that email, some people don't see their email or whatever. Yes, Debbie.
Okay, I just want to understand it. Hand delivered, whatever, it is, right now it's 14.
I'll take the cookie.
That's law, 14 days. So if you hand deliver it and we count days by counting that day or the next day? Like if I serve it on the first, is the first day one,
Next.
or is the next day day one? Which would be the second.
So.
Well, it depends on, this is just a definition of notice.
What are
Okay,
people's
so, okay, so right now, we hand deliver and we have a 14-day notice, or however we count it. But if let's say I email it and they respond to that email, I still have to mail it. And then when I mail it, once I mail it, then they get an extra 5 days.
The way this is written right now, the 14 days that comes subsequently. Right now, it's
Whatever
just
the days are.
what's noticed. What's noticed. And the way this is written now is that notice is anything on this list of 5 things. Any one of these 5 is notice. It's just that email alone is not one of those things. It's only email and mailing. It doesn't have to be that way. It's up to the committee.
Well, I think if they respond back to you, then you know they got it.
Well, we can't put it like that, I don't think. So we have to just decide if we're gonna put. Right? We're not gonna write if you got it or not, right?
Or you could just take email out. I think
say take email.
the options should be, if you're gonna leave it, I think if it's gonna be email, it should be email and mail, or take email out and just don't have email as an option. Because just because someone sends an email doesn't mean someone receives an email. Technology has way too many barriers for various reasons of technology, accessibility, and I just think that that's just not a reliable source.
What about written correspondence?
Take out emails, fine, but.
Yeah, just.
We're taking out
yeah.
emails.
Yeah.
I
I'm
disagree.
in favor of taking email out simply because there's no prohibition against sending an email saying, watch for this notice, it's been mailed.
Yeah.
And-
Right.
Okay, are we in the sense that we're just gonna, okay, so we can take out email and just say actual notice is hand delivered, delivered by the sheriff, mailed, or posted on the door if we don't know the address.
I would counter with, what if you are staying with your mom because she's sick and you don't get your mail, but you could get an email because you're checking your email consistently? I mean, what's gonna happen if someone that
So this is like the rebuttable presumption section. I'm sorry, I know that we've been over this. But I feel like I may not be the only person thinking this. Can you explain? So when we're defining notice, then the next step is you're saying the rebuttable presumption. What does that mean? That means like you can answer back, and these are the conditions under which you can make a case
What
that
it
you
means
didn't get
is-
notice?
So the definition of notice requires receipt.
Yeah,
You know that someone received something if you hand deliver it to them.
sure.
You still have to prove that in court, but I hand deliver it to you, we know that that's happened. When you mail something, you don't know the
Right.
day that they're gonna receive it. But you want some sort of finality here. If you're gonna allow people to mail stuff, which makes sense, if you can't find the person physically, you need to be, the landlord has to have some avenue to get the information to the individual. So we're gonna allow it to be mailed. Now, we want to create a time period that all parties know upfront. You're gonna be presumed to have received it if it's mailed. And that's what the rebuttable presumption is. It's saying if you mail it, there is a presumption that you received it 3 days after it was mailed.
5 days.
The rebuttable piece is you can go into court and show that you didn't receive it. So it's a presumption that you received it 3 days after, and if you can prove to the court that you didn't receive it 3 days after, then that presumption no longer exists.
So.
I
let the-
think that, sorry, can I just
Yeah.
respond to that? In that case, I think that, you can prove just as easily that you never opened the email, but maybe it's too tech. You know what I mean? Like yeah, sure.
Okay,
But I
but
have
still we
better
have a
forms
policy
of response.
decision.
Yeah, what if people?
Do you want to take out email entirely? Or do you want to leave it in and leave it with, but you still got to mail?
It looks like we're seeing some had not, can we
I think
do a hand situation?
Draw. You guys understand the choice?
Yep.
The choice is, there's a list of things that are noticed. It's or this or this or this, or emailing plus mail. Do you want to leave that in or take it out?
So raise your hand for email plus mailing.
Who wants to leave it in?
Email plus.
Mailing.
Oh.
1, 2, 3, 4, 5. Who wants to 6? Who wants to take it out? 1, 2, 3. Okay, leave it in. All right, moving on.
I'm neutral. It's not the end all be all for me.
Okay,
I just wanted to make a point that once you get to court, they're emailing all the time.
Correct. If you make an appearance in court, then
Mhm.
They
court will
email to them.
typically share information based on the court proceeding via electronic. Yes.
okay, let's move on or we'll never.
Yeah.
We've made it through page 1, everybody. I'm glad to see you
We're-
guys are so into this. Okay.
We are leaving it in.
So the next change is the definition of immediate family, and this originally said adult person related by blood, adoption, marriage, or as defined in any other jurisdiction, and it was a little messy and referencing to other jurisdictions that aren't the state, so it's just been cleaned up here to say an adult person related by blood, adoption, civil marriage, civil union, and then the remaining sections. So it's just a clean up there, and I referenced that from other definitions of immediate family in Vermont law, so.
Thank you.
Okay, moving to the bottom of page 2, the top of page 3. So this is tenant obligations, payment of rent, and I've added rent increases. And then you can see the language on the top of page 3, new subsection C, a landlord shall not increase rent more than once in any 12-month period. If you all recall, there was a section that was further down. And it was in its own standalone section. And it said that, at least in 772, it said, can't increase rent more than once in 12-month period. But then it had a lot of scenarios where if an individual purchased the property, the purchaser could increase rent. It was CPI plus 3%, I believe. There was question about whether to go to cost. There was some language about if the rent had increased 6 months prior to the purchase, how do you calculate the increase? All of that was stripped out. And so what remained was you can only increase rent once in a 12-month period. Given the fact that this subsection B already existed here, which states what the notice period is to increase rent, I felt that if that was the only provision left, it made more sense to go here, statutory.
One of the things, just to clarify, this is a change, okay? It's a change in response to conversations and conversations and testimony. We basically stripped out the rent control provisions from 772. There were maximum increases. They were limited to resale of the building, but there were still rent control provisions. They're gone. All that's left is the 12-month.
And caps.
Yeah, they were
If
caps.
you call it
Yeah.
caps,
That's
those
what
are
I mean.
gone.
They're caps. They're gone. Yes, Joe.
How would this apply to a new landlord or somebody who newly purchased a building? Because at the time they're increasing the rent, if they were to purchase it and increase rent, they would not have been the landlord prior.
Yeah, it's a
They would be
landlord, not
a
unit.
landlord, right?
I would argue that they would be restricted from increasing the rent if it had been increased in a 12-month period prior to their purchase.
But it says it's the landlord decision. It doesn't say the building, the price of rent in the specific building. It says a landlord. And if I was not a landlord 6 months ago, that law does not apply to me.
Yeah.
It applies to me today.
That's
I
right.
Joe's aware now. It's good. No, that's a good
Can-
point.
Happy to add language to clarify.
No, I'm.
He's eagle eyeing it.
What's,
wanna make sure.
okay, everybody understand the policy. Let's not talk about what this, let's not argue about what this language means. Let's decide what we want it to mean and he will clarify.
I think it's perfect the way it is.
Well,
Oh, you do? Okay.
if the previous property.
Yeah.
And the previous, so let's say the previous landlord didn't have a mortgage, they wanted to stay under a certain amount of income, so they had homestead exemption, that whole scenario. Their expenses may not be as high, so they might be charging $400 a month for rent. They sell the building, I purchase it, now I have flood insurance, I have a mortgage at whatever the rates, 6%, whatever the rates are. And I have increased cost. There's no way I could honor that $400 a month rent.
So you'd like the language to be clarified or?
Well,
I'd say.
We're not
if
gonna
I'm
argue
a
it.
current landlord and, okay, maybe I could live with that. But when you purchase a building, you don't have the same expenses as the previous landlord had.
Right.
It's a good point.
It's a good point, and it's just a question of whether
So do,
we
right.
can write it so that it says, that if a landlord purchases a building, then they can raise the rent once in 12 months, or something. We can do that. It's a question of what you want. Yes.
I think that if I'm okay with tying it to the landlord and not the unit, if we give a lot of notice and help with finding a new place to live from the previous. And, maybe the landlord will negotiate, the selling landlord can negotiate with the buying, like, help me out with.
Well, that's coming,
I know, yeah,
that's coming up. That what she's saying, I'm just gonna play the clarifying role here, is one option is make it clear that if you buy a building, you're a new landlord now, you can raise the rent right then.
Right.
And then you can't raise it again for 12 months. And she's saying, yeah, I can go with that, but it depends in part later on what we're gonna do for the tenant who has to leave. Yes, Debbie.
Well, if I I see apartment building for sale. I buy it in 24 hours.
Right,
I can't give a 60-day notice on raising rent. I now know what my expenses are. That rent has to be raised because I cannot afford to do what the previous landlord had done.
Then you can't buy it.
Yeah, then don't.
I don't
Yeah.
buy it.
Because that's not really fair.
Well, are we
to
trying
the
to make this
tenants.
business attractive to landlords?
And we are, and there's lots of provisions in the bill that do, but not every single piece is gonna be tailored to that exact lens.
I think you would, if, let's say, Debbie,
Yes.
that we do, oh, by the way, Tom, I don't want to talk, you have your hand up, I think. You're not just gesticulating, you're not just thinking, right? You actually have your hand up. Yes, so.
Not emphatic.
Say your piece.
A landlord should not increase rent more than once in any 12-month period during which they are in possession of the building.
Sure,
In this case,
Yeah.
if it's gonna be 60 days before you can raise the rent, that's part of the cost of the transaction.
yeah, I think that's, Debbie, the issue. You're raising a good issue. I think you just, if it was the language that Tom said, You just have to work that into the purchase price or the financial cost of doing it. Do people feel comfortable making it clear that it's, as Tom said, that it's the landlord? In other words, a given landlord
Not
cannot
the
increase.
unit.
Yeah, it's not the. Are you, in other words, how did you say it, Tom?
So you don't remember.
In possession of the
Like-
building.
I think it's just a policy, it's a policy decision. Do you want
Yeah.
it to not apply in the event someone purchases a building?
Yeah,
If that's the direction you wanna go, I will draft you something that says.
Or you could say rent on a unit shall not be increased more than once in any 12-month period.
Yeah, well, however he says
If
it,
that's the
let him do it and bring it back to us. I think that we can do that. Let's do that and look at the language, okay? Clarify the John Charlton approach in your own words.
Okay,
Okay.
so if someone purchases a building, they would not be limited by this section.
By some prior,
they get a carve out.
they get a new shot, okay?
It means the clock starts over.
Yeah. Thank you.
There's new owner.
There's
Good.
just, it just means there's
And that's
different,
immediate? Meaning that the rent
No, it's 60 days notice.
okay.
So what's next? And we're gonna get a chance to look at this again, believe me. But,
Okay,
I'm not.
so the next section is the section related
Oh, I
to
wasn't-
residential rental applications. This is the section where it prohibits the charging of an application fee to an individual in order to apply to enter into a rental agreement. That's the subsection A. If you all recall, the bill as it was introduced included a definition of what an application fee is, and there was discussion about whether that should include background checks and credit checks. The bill as it was introduced included the application fee, included a background check, but not a credit check.
Right.
So that has been amended. So what you have here is, as used in this section, an application fee means any fee, charge, or cost to submit a residential rental application, including any third-party processing payment. Then it separately says a landlord or a landlord's agent may charge actual costs to conduct a background or credit check of an applicant. And then it includes the statement that if the applicant provides a credit check as part of the application, then the landlord shall not charge for a credit check. So you authorize charging for background, and then you're requiring that they can only charge for actual costs.
Tom,
I feel better if unless the tenant or applicant provides a current credit check. My Experian report from 2 years ago.
okay, good.
I have it.
Got
Well,
it.
we have to define how recent.
So adding
it
the
has to
word-
be.
Oh,
It's gonna be like that moment, or is it have to be?
oh, yeah.
Well,
Provides a credit check within the past 90 days.
Yeah.
yes,
I'm down the track.
Why doesn't it say background and or? Why does it only say
I
or?
was gonna say.
or is and, or means and, or.
In the legal,
The legal
In
word,
the
didn't you,
legal-
didn't you
I'm
know
not a
that?
lawyer. I know what I thought it was.
good to know.
Okay, so we're gonna put,
Too. There's all kinds of words that just randomly exist.
so we want to clarify
Clarified that it's
the
reasonably
time
current,
frame
okay.
of current, reasonably current, not, like my credit looks a lot different, 8 years ago than it does today.
Shall we say within the last 30 days or
30 days.
Joe said 90.
so?
30
I
is,
say 30.
it's
Okay.
tough to find a place if you have to get, like, yeah.
60, right in the
What
middle.
was, you guys who were here when who was here when the whole,
Okay, you seem to have it 60 as splitting.
Well-
No.
Well, here's the only thing I'm just gonna nudge on this is if we're gonna be talking about credit checks and timeframes, if they've just recently pulled one and they have to pull it again, every hard pull on your credit dings your credit score and reduces your credit. So if we're going to not take that into effect, then I just, like, if, you know what I mean? Like, if they're gonna do a credit check and then they don't give them the
So that would, that would mean a longer time frame.
Can we
That would
clarify
mean
that that
that-
actually happens, though? I don't think just pulling your credit, period. I think pulling your credit for
No, it,
your own application
If
might
you pull
actually.
it. it's
But if you
different
pull
than
it
if
just
a
to get the
bank does it.
information.
it depends on what they accept. So if you check your own credit on like Credit Karma or something like that,
That dings it.
that, no, well, no,
Oh,
that doesn't ding. If you check it yourself, if someone pulls your credit, that does ding your credit and it does apply to your credit score. I know because I check the credit regularly.
Because it looks like you need loans
Yes,
to do,
yes.
to live your life.
I do.
Yes.
So that looks bad.
Yes.
Go ahead.
Yes, actually,
My experience is that when landlords have full credit checks, it's a soft
A soft
pull.
pull, okay.
I truly don't know the answer when I'm asking this. Is that something that we can legislate, that like any pull cannot be a hard pull?
No,
I would need to ask a separate member of our office there.
It's just it's just a question. I mean, if we're getting down into the weeds about each and every sentence in this bill.
we sure.
do you know? Do you know? Okay.
Well, I'm just saying, I think that's something that
No,
impacts
we don't
someone's
want, no,
livelihood.
mine's
you know what I
getting,
mean?
mine gets dinged
I just want to know one thing. Is it okay to say within the last 90 days?
I thought we went down the middle with 60.
No,
Is it-
90.
Oh, 90, okay.
Okay.
This is-
Okay, put it
The applicant
90,
has the
all
option
right,
for the
okay.
public library and do it.
All right, now, I just want you to know, you guys, you have penetrated to a level that witnesses, that people who are total experts sitting in the audience here are shaking their heads that they don't know the answer to. Into the
We're
weeds.
really getting pretty weedy here.
Okay, all right, go ahead, because there's more.
It's a
There's
serious,
more.
because it's a serious thing.
It's
Well,
this is your livelihood. This is not
Right.
like,
I
it's not
agree.
even your car. This is
Right.
your
No,
actual
I agree.
bottom of Maslow's.
Fundamentally, I also think that the question is policy decision of, is this the cost of doing business? Or is this the cost on the applicants to try to find housing? And what do we wanna, where do we wanna?
Right
try
now,
to
the way
find the
it's written,
balance.
the way it was written and pursuant to our last conversation was that it's charged to the applicant for the credit check and background check only, not any other charge. But if the tenant provided it, then no, you couldn't charge. So the answer was so far that it was not a cost of business, it was passed on to the tenant. Which is like
still
65
unnerved
bucks.
by this because I thought that the current law said you can't
I thought so
pay
too.
fees.
I thought so too.
That's a different, that's a different fee.
The current
Wait,
law.
this says application fee, and what we heard from legal aid was that that is interpreted as no fees, period.
So the current statutory section is there in A, and it says that the landlord shall not charge an application fee to apply to enter into a residential dwelling unit. The term application fee is not defined. I personally have seen applications that charge a fee in violation of that section, as it was a fee to simply submit the application. So as in everything, there's always going to be individuals who aren't complying with statutory requirements. What it doesn't say is it doesn't say anything about a background check or a credit check. So if I were a landlord and I wanted to make the argument, I would argue I'm not charging you to apply. You submit your application, and then if I want to move you forward, I'm going to do a credit check and I'm going to charge you for that.
So what we, just to clarify, because this is a policy decision, okay? Here's what happened so far, and we can change, okay? We can change our minds. First, we heard, this is what our esteemed counsel said, it's unclear. It would be good to clarify. And so we decided, and on a prior draft, clarified that they could charge for a credit check unless the applicant provided the credit check. Then in our conversation that we had last time we took this up, other people here said, wait a minute, what about a background check? And so we added background check in. There's no we can provide clarity the other way. We can say that they cannot charge for a credit check and a background check. In which case, it's a cost of doing business that's spread into the rent. And so it's up to you. It's a policy choice. The policy choice that this followed, this draft, was that you could charge the $65 to the tenant. If you want to change that, you can. It will affect the rent somewhat, but
In the long run.
yeah. Do you want to go ahead with this draft as is? Maybe you should show the rest of the section and then people can decide.
That's generally it on this section.
And then
The only
security.
thing is the sub C, so back to kind of that conversation though, Rep Dodge, one of the questions is. I would ask, there's no enforcement mechanism for this section, so it says a landlord shall not charge an application fee. But there's really no entity or individual that upholds that or consequence. So what the subsection C here is, it would add that it would be an unfair practice in commerce for a landlord to charge an application fee moving forward, which could be enforced by the Attorney General or the state's attorney, or it could be enforced through a private right of action against the landlord.
Okay,
My understanding from talking to, from talking to people who have contacted me saying, I was just charged an application fee, and I am aware that the statute says that I cannot be charged an application fee. Is that they get a case, they get representation saying, no, the law says no application fees. Because how are we to distinguish between an application fee, actual cost to conduct a background check, if you can make the case that it took you administrative hours and staff time and office rent costs to stand up, the whole effort of conducting the background check? Do I have to, as a tenant applying, pay for your utilities and your internet and your membership to the rental background check, like service? So I feel like we are creating this new language that is completely speaking against language that exists currently. I think that in the wild, this is a new thing that clearly at some point we had said as a legislature, this, it's not right that somebody could say, sure, yeah, you can apply, when they may not have any intention of letting you, or they can use it as a barrier. We don't have a limit on what an application fee is. I thought that the point of that language was to say, no, you don't pass that to a residential tenant, you can pass it to a commercial tenant.
yes,
So a landlord, if they charge an application fee, that doesn't necessarily mean that they're doing a background check or a credit check. So that's what's against the law.
Right.
But as far as, isn't it good stewardship to be able to ask for the background and credit check so you can make a decision on whether this person is a good risk as a tenant?
well, she's
And who
saying
pays for
that's who
it?
pays for it.
So,
There's no
I know
question
this
about
is
doing it, it's
minuscule.
just a question who pays for it.
but in 102 people that have moved in 6 years where I live, it's $63 per person. That's 18 and above, and no one has ever said anything about the background and credit check. And this is low to moderate income
No, but wait, it's for a background check.
and credit check. Both.
Yes. Debbie,
I was just gonna say about the application fee, I mean, I'm just gonna assume that landlords have, if you wanna, look at this apartment, whatever they have for rent, here, fill out an application. There's no fee associated with that. In fact, we can email you an application. And you can just, if you can't process that, you can just write the answers on a piece of paper, take a picture of it, send it back.
But some
It's like-
landlords do charge an
Well,
application fee.
we're not allowed to.
No.
I think the policy question, I'm gonna put it as black and white as I can. Option one, we leave this language as it is with the clarifications requested. I think it would be hard to put a maximum in. Actual cost is the best we can do because the numbers will change over time. Not like we can say, which shall be less than $65.
Right.
However, that's one way to go. The other way to go is to take this language out and to clarify that an application fee may not be charged, and then that means you can't charge, write the language, say you can't charge for credit check or a background check. It's one way or the other. He can make the language clear. Don't worry about the language here. He can make it clear. The question is, which way do you want to go? Do you want to have the cost of doing that applied essentially to spread into the rent? Or do you want to charge somebody who applies the amount of the actual cost? I think that the only thing I can say about the fear that the sky's the limit there is, well, we have that problem all the way across everything we do, which is the law it's hard to enforce the law in Vermont. Period. I mean, I would say that's subsumed into the larger problem of landlords charging application fees when they should. But anyway, we can go one way or the other. What's the pleasure of the committee in the next draft?
I guess I have a-
I like Gail's point. And I like Gail's testimony that nobody has ever, they just pay the actual fee.
Yes,
I just have a question on, my question is around how, how many landlords currently charge this practice, and if this would make it mandated that they would have to, or is it at the discretion of the landlord whether they choose to or not?
it's at the discretion.
So this would not mandate that
No.
landlords now have to charge?
No, it's
Okay.
they may.
Okay.
They may.
Yeah.
Shall we, in this draft, leave it the way it is for now?
I would suggest pay for half the actual costs. Charge half the actual cost. Well, otherwise,
I would go towards no fees whatsoever because there is no enforcement. I mean, so.
Yeah, yeah.
So with anything, when someone is breaking the law, what happens is if somebody were to complain about it, at least there's something that's structured and codified. So of course, there's not going to be people knocking at the door for any landlord saying you're doing this or that. But if a tenant were to go and sue you, then it's already in law, statute.
There's no penalty.
For if they sue the person,
So
they would at least get their money back for,
Is
But
there
they
penalties
pay, right?
under 2453?
there is, if this was in statutes,
There is a penalty.
yes, that references to the Consumer Protection Act,
And there's
which includes penalties.
penalties, yeah.
Okay,
I'll tell you what we're gonna do. We're gonna leave it as is, only because it will be very easy. It will be very easy to go the other way. I mean, all we're gonna have to do is strike this provision and clarify, right? I would say that there's a question here as to whether who pays for, I'm gonna note.
Also, I asked the banker guy about the soft, I forget if you know the guy. The banker man.
Celia?
Yeah, about the soft, hard.
this is hearsay now.
It is true. Anyway, he can provide us with information on that at some point.
Okay,
On the soft,
The
hard
effects of
pull,
your
Which
on your
way?
credit.
got it, okay.
not a cheese pull.
Okay. Go on. Yes.
Quick question. Is the opposition because it's the credit score that the,
No, it's just a question of, she's worried about the money.
okay.
So
I
he'll
mean,
give that a stand.
You know, people apply. You can argue either way. The landlord can say, you know, I might have to do 5 or 10 credit checks, and I don't want to pay $650. The tenant can say, I might have to do 5 or 10. Well, actually, background check. The tenant can say, I'm just going to do 1 credit check and give it to all the landlords, but I guess that's a fact, actually. The reality is by giving the tenant the ability to do the credit check, it means that they do it once and they use it in all of their applications. And the landlord can charge for the background check. And I don't even know, I mean, I know it's like $65 for both, for both.
For double.
But for both, you know what it is just for a background check?
Most of them don't split it up.
Uh-huh.
It's background and credit worthiness. It's not even called a credit check.
And then we've heard testimony, I forget what year, if it was with you, different organizations like CHT, for example, have like, you have like a larger firm that's, right, like it's gonna be different for different people, right?
Chris, you say your name.
Chris Donovich, if I could trust. Yes.
You,
People can use different third-party vendors to do this.
People cares. Anyway, so there's variables.
I think that I'm putting a hold on. Okay. All right, okay. Think about it. All right, this is the kind of thing, it's perfectly natural for us to have different views. It's the kind of thing, maybe we go one way with some and another way with the other and see where we go. Okay. Security deposit.
We're on page 4.
Yeah.
Okay, security deposits. So currently, in statute, security deposit, any advance, deposit, prepaid rent, however named, which is refundable to the tenant at the termination or expiration of the tenancy. This section goes into what can be deducted from a security deposit, when a security deposit is required to be provided back to an individual. And if the security deposit is not provided back to the individual within the time frame specified in statute, then the landlord forfeits the security deposit. What's being added here is, starting here on A2, a landlord shall not charge or receive a security deposit exceeding an amount equal to 2 months' rent in addition to any rent for the first month paid. So that's as the bill was introduced. What is then added here is this new sub 3, which says that subject to the requirements of this section, a landlord may charge a separate security deposit in addition to the amount authorized in subdivision 2 as a condition for allowing the tenant to have a pet or pets during the rental period. So a pet deposit would be a separate, there is no cap there.
Right.
A landlord shall not charge any amount under the subdivision for any animal that mitigates a disability.
Just so you know, where this comes from is Burlington's experience. First, they adopted it without this, and people with pets couldn't get in the units, and so they put the provision in 211, which I assume works okay, I don't know. Yes, Joe?
Maybe we should ask them how they treat the whole mitigate the disability portion of that. There's a whole lot of non-service animals that are actually trained roaming grocery stores and every other business in this state.
It's emotional support animal, and that's a law by the age.
For, yeah, but is there any way of like, there's just nothing.
You can get them online now from a real doctor.
Which is probably cheaper than.
I think the question might be how vague that last sentence is.
Debbie?
Okay. Service dogs and emotional support animals are not pets.
Right.
Oh,
Right.
Do you ask them?
They are not
Yeah.
pets.
So, yeah, you show.
Trained, and this is going back 10 years, the last I knew that they are trained specifically to help mitigate a diagnosed condition.
not ESA.
But that's true, and that's why everybody goes that way, but I've had situations where I've had to say to people, yes, you bought a vest, you put it on there, it says support animal.
Jess, would you identify, oh, I'm sorry, go ahead. We have some knowledge in the audience. Jess, would you identify yourself?
Thank you, Chair. I'm Jess Simon from the Champlain Valley Office of Economic Opportunities Fair Housing Project. And this is a great discussion. I think it's really important to note this distinction between pets and assistance animals. So under both federal and state fair housing law, any person with a disability, and that could be a physical disability, a mental, emotional disability, and being in recovery from substance abuse, has the right to an assistance animal to give them full use and enjoyment of their home in the same way as someone without a disability. An assistance animal under fair housing law is different than a service animal under the ADA. So an assistance animal could be a service animal, it could be an emotional support animal. And there's no documentation needed to show what that animal does, but a landlord can request documentation from a medical or service provider that says this is a person with a disability, and because of their disability, they need this assistance animal in their life. Thank you.
Okay, so pet deposit.
Do you
Authorization.
put this whole thing, do we need the last sentence or do we not need the last sentence? In other words, Jess, someone was saying, Debbie was saying, if it's a service animal or a emotional support animal, it's not a pet.
So do we have to state that in our bill?
I think we always need to state
Okay,
things that are supportive for people with any sort of disability, because we don't otherwise necessarily recognize it.
Correct me if I'm wrong, but it also has to do if the landlord can accommodate I'm gonna use the emotional support animal. Let's say you have a small horse and it's gonna need, a place to be,
Right.
stable outside or whatever. So the landlord has to be able to accommodate. It's in that statute.
I think that's by implication.
There would have to be some reasonable grounds, and
Right,
I would say
yeah.
that federal and state fair housing law has this covered, and you may not need that last sentence. because-
but we're saying members of the committee would like to have it
For clarity.
for clarity and for advocacy purposes. And I think that is just as well.
Leave it as is.
So let's leave
Okay,
it
let's
as
leave
is.
it as is.
Can we just add the reference, like,
Well, the reference is there because it says pets, and it clarifies animal in the last line, which service and emotional support animal is not a pet. And I think that is the clarification and the separation of the two.
Or
Yeah,
do we want to put service or emotional support?
I think the way it reads is fine.
Fine, okay, all
I
right, let's
think
leave it.
that-
Go on.
Okay, so then we get to subsection C. And this is where, as I mentioned earlier, the landlord shall return the security deposit within 14 days.
Yeah.
So now
This
we're
was an attempt. Don't take this absolutely literally. This is just an attempt to address a problem. And if we want to reword it, rethink it, that's fine. Go ahead.
So this is the top of page 5, so this is adding in that if a landlord terminates a tenancy under subdivision 4467D or E. So this would be circumstances where the landlord has to repurpose the unit.
Right.
Or if the landlord is terminating the tenancy at the end of the rental agreement or upon a certain time frame of notice to the individual. So this is not the tenant causing the termination, if you will, due to non-payment of rent or failure to comply with the terms of the rental agreement. Pause, because I believe you have a question, sir.
Okay, so in other words, this is saying if the landlord, this is the 4467D or E are the bundle of actions that the landlord is in control of. And what you will see later is that those situations, we require a 3 months notice. This is trying to get the landlord to go in towards the end of that notice period or sometime in that notice period, do a walkthrough, and if there's no damage, to return part of the deposit. The thinking being, if a landlord is essentially kicking the tenant out for reasons that have to do with the landlord, that's fine. That's permitted, but the tenant has to find a new unit and has to have the cash to put in another security deposit.
Right.
On the other hand, I didn't want to put in all of the security deposit because of course the landlord's going to worry that, well, gee, what's going to happen in the final month or so? And so you want to have some there. That's all this is. That's what this is. It's just an attempt to make sure that the tenant has, because right now under the law, the landlord doesn't have to give the rental deposit back until 2 weeks after the end of the tenancy, which means the tenant has already had to move. So, yes.
What is,
Go ahead.
I'm sorry. Yes, go ahead.
I think that this whole section really leaves out the people who are the most vulnerable in our most vulnerable to becoming homeless in our state. And I would go back to number 2 and not allow for a security deposit that's 2 months rent plus. I would counter that we should not allow first, last, and deposit to be the law of the allowable deposit for a rental unit in our state. But particularly if we're not going to give a tenant access to any of that money when the unit is being taken out from underneath them, I think we're forgetting that it is impossible to come up with first, last, and deposit. We already have first, last, and deposit committed to a unit. It's impossible to come up with first, last, and deposit in 60 days when our current rents are cost more than 50% of a household income. It's not reasonable. It's really not reasonable or sane to assume that somebody can achieve that. I strongly, strongly, strongly object to all of this.
Yes, Debbie.
Don't we have agencies that help with rent and security deposits?
Not to my knowledge, no.
Do other folks feel about this in the committee in this section that similar to what Elizabeth said, or no?
I just want to add where the 2 months came from without justifying it. There was a bill introduced by Chairman Wood that would limit security deposits to 3 months. We received testimony that some people charge 6 months. We felt that we did need a limit. I picked 2 months as a compromise. It certainly could be 1 month. This is a policy issue. Yes.
Like I said 2 weeks ago, and I'm playing devil's advocate here. If we make it so impossible that landlords aren't going to want to rent their units. So there has to be some bit of a balance that protects and supports the tenant, but just as much as the landlord, so that they will be encouraged to rent their units.
Yes. Ashley.
Thank you. Yeah. I think that's something that has been on my mind. I have a question on page 5, number 2. What part of the idea of doing a walk at the end of a tenancy is damages?
Right.
So what if there are damages to the property that exceed the security deposit?
Yeah,
Like,
my
that
feeling
just
is
doesn't work.
if this, no, the way this should be written somehow. Well, let me use your example. If the damages exceed the first security deposit, then they don't give anything back.
But if you're doing it prior to them leaving, I'm just like trying to understand the timeline here.
Well, here's what I intended, and then you guys work with it. I'm picturing a tenant who is not messing up the unit, okay? A tenant who is a good tenant, paying rent, obeying the lease, and they're being evicted for reasons that have nothing to do with them. It has to do with the landlord's needs, which we are not prohibiting in this bill. And I'm saying then, I'd like to find a way to get them some of that money back before the end of the lease, so they can find another unit, and we not have to be evicted and go through that whole thing saying, well, and it would seem to me the way you do it, and I'm just throwing this out, the way you would do it is sometime during the 90 days, you'd have a walkthrough, and if the walkthrough reveals no damage or minimal damage, you subtract that. Let's say it's 2 months, and let's say it's $2,000. If there's $500 damage, you subtract $500 from the 2,000. There's $1,500 left, and you give the tenant half that, so they'll have something to go looking for a new unit. And then by the end, you do a final walkthrough, and if there's no more damage, you give them the rest right then, so that they can move. It doesn't inconvenience.
And if there is damage, then there's still half.
Yeah,
of the-
whatever the damage is subtracted. So the damage is so much that that there's nothing left. Well, then they don't get anything. But the idea, I know that it's
This
an
makes sense.
inconvenience, but it's an inconvenience to the landlord. I know that, but there's such a need for the reasons that Elizabeth said, I felt.
Oh,
There's
yeah.
such a need to try to get cash to people so they can roll it over into a new lease. I was just looking for a way to do that.
And I like that it
This is a
has,
rough draft of
if
that.
you're-
That's all it is.
I think it rewards good behavior because you get, right, you're holding back that amount, so it's some guarantee to the landlord. And it's incentive for the tenant to leave on good terms.
Right, but it was only part because you really can't, a landlord can't be sure
Yeah,
where
that's
things
it.
stand until the end.
Right, that's what I'm saying,
Right,
you're
yeah.
giving some guarantee.
I think it's
And
good.
you're giving incentive to
Because
do right by the.
I think it's good. I mean, if I was kicked out on the street and I didn't have, I wouldn't be able to come up with another security deposit if I didn't get mine partially back for the next place, right? But I just want to be sure, Elizabeth, that you're advocating though,
Less security, right? Or-
in a different, like it's a different, like not of this policy language, but in general, that things change in that arena, like not having the same. Like you don't have an issue with the you have an issue with the larger picture of how those things work.
How big a security
Right.
deposit could be, is that right?
I have an issue with, if a tenant is required to, if a tenant is required to come up with first, last, and deposit, they should be able to, upon, notice of termination, they should have access to all of that to be able to roll over into the next apartment. It is not fair for
Okay.
people who, yeah.
Immediately,
Well, wait, the question is
And-
when?
yeah, when?
In other words, let's say, first of all, let me just, because we might be onto something here. Let's say, do you feel that it's okay for the landlord to deduct something if there's been damage?
Yes, I do. I do think that there should be required proof of the cost of damage.
Out of-
What?
I'm seeing some heads nod.
We agree. I think most people agree. Yep.
Okay,
And
and do you think that they should have, when do you think it should be? I there's nothing magical about what I did. I just figured they've got 90 days. Sometime in the 90 days, they got to get access to as much of it as they can, but there has to be some holdback to deal with that final period. But I don't pretend to know how that should be.
Right, because they can't take it back. Like if they gave it all to them again, they would have to take it back after and that wouldn't be.
Well,
as-
that
wouldn't
that's-
Right.
What's, what we're.
Right, I'm just raising. Um. Moving moving into the new place. I'm just trying to think of the timing between when you get your money and when you have to give that down payment and whether we can create a buffer also on upon entering. You know, when you start your new lease, how quickly, like, do we let people have 14 days in to give the rest of?
Right now, the law, I don't think the law, I'm not speaking as chair, I'm speaking my own personal view. I don't think the law is very good right now. The law essentially says that the landlord gives the money back 14 days after
They've left.
they've left. My assumption is, without knowing, that people, when they get the notice, are gonna want to rent. Yes,
That's not the law.
well, what is the law?
The law is that you need to get your security deposit back at 14 days at the latest.
Yeah.
And if you don't receive it by day 14, you get the whole security deposit.
Right, okay.
So hypothetically,
Yeah.
there are
so-
landlords out there who, again, are doing the right thing, just
Yeah,
like if we're
let's-
gonna continue to
Yeah.
talk about tenants that are doing the right thing. There
yeah.
are good landlords out there. And they are giving that security deposit back as soon as people move out. I just like, I have to say it.
Okay, that's important. Actually, you know what? For a lot of reasons, it's good for us, part of the time at least, not to focus on the worst actors on either side, but to focus on the good actors. It's always a problem when we make laws that only are addressing the awful actors. So,
Maybe
And
we
it's-
should instead just focus on the most vulnerable landlords and the most vulnerable tenants, because that's. And when we ask who's being left out,
Joe, and then I'm gonna make a proposal, but Joe?
Okay, my point was just, I mean, the best time to do a inspection of a previously rented unit is when everything's gone.
Mm-hmm.
I mean, if you pulled all the furniture out of my house, I'm sure I could find some things that I didn't know happened. You know, some drawings from a 2-year-old at some point, or.
Or the DIYs you
Yeah.
do wrong.
Yeah, you know, just little things here and there. So
I've got a few holes.
the idea of like not having, like giving back a fair chunk of the security deposit before you've actually really had a chance to
Yeah.
look at the unit is kind of,
But you.
I think it's a good
Yeah.
balance. I think you're incentivized. The way that we have it now, of course, if you're a great tenant, you know, you're being fair, you're giving back. But what you're saying is we're trying to create an incentive for when there might be some questionable,
Yeah.
right? Like we're setting some kind of obligation
Okay.
on both sides.
And I don't-
I'm happy with this, the way you.
and I don't love it, but the fact that it does apply to D and E, which are, refresh my mind again,
Yeah, they're the ones the landlord is
like selling or,
selling,
family moving
converting,
in.
Yeah,
renewing, et
it's not
cetera.
for-
It's not
It's
paying the
not-
rent.
yeah,
Yeah.
it's not just.
Okay, but I'm gonna throw out here the instruction draft. I'm gonna throw out an attempt at instructions for our esteemed council.
Not,
All right. When you redraft this, first of all, what was it that, a very basic thing? It wasn't just about returning. What was it, Elizabeth? Proof? Yeah, the landlord has to submit
Right.
some sort of itemized proof of.
it's in there.
I've gotten one of those.
but also not just proof of damage, but how much, like estimates of
Yeah,
how much it
estimates.
actually costs. to fix.
Estimates, and Debbie's nodding, so some sort of estimate.
They're laughing.
Okay.
You want the landlord, when they submit the written statement itemizing the deductions to include.
What's the current one now, Debbie? Do you know?
I don't know, but I mean, yeah, when we do a security deposit,
Like a checklist?
a list, we itemize
Right.
the damage done, and the cost of the repair.
You know, like when you get a rental car and you do like a loop?
Yeah,
Okay, so I think there should be a preliminary walkthrough.
Yeah.
But I don't think it should be land terms it, the actions, the tenant. I would say not later than, I want to split the baby 45 days before the end of the termination notice. And that a final, no, and I would put it at the request of the tenant.
Right.
If make this at the request of the tenant. If a tenant doesn't want to go through this hassle of having the landlord come through twice, then they don't have to. They're not getting their money back. But at the request of the tenant, they do. And then that there's a final walkthrough at the end, and the remainder of the security deposit, minus any damages discovered, has to be paid back. When? At the end of the tenancy period? What do you think?
Just don't get back the rest of your, I won't get
Why
it.
not?
Well,
If you, sorry.
No, no,
I don't know
no.
what you're saying at the
I'm
end.
assuming no, whatever is net after damage.
You get it at the end.
I'm sure that damages will
You've seen some
be
damage.
large compared to what the deposit is. So they wouldn't
Yeah.
get anything back. And you'd probably be lucky if the tenant would let you in before or house,
You know,
before they leave.
I think that, remember, I got the picture, I've looked at some of the evidence we've gotten. You know, stuff that's submitted. There's no question, there are tenants who are not getting anything. I mean, they've trashed the apartment. Okay, we're not talking about them. But I think there are other tenants, I know them, who clean their places, you know, and leave them in pristine shape. I just want them to be able to get their money back sooner when they need it. Okay, let's try that, draft it. Let's see what it looks like. Make it 45 days. Reference a final walkthrough and the return of the remainder of the deposit minus any expenses at the end of the lease.
So the only thing I think you need to do is change it to say at the request of the tenant and change it to 45. I don't know if you
Okay.
need any of the rest of the stuff there.
Well, don't you need minus any deductions? You have that. Okay, try it that way. Okay, yes.
No, never mind.
You sure? Okay,
Yeah, because it'll.
all right, go on.
Okay. What you have here is in the E, if the landlord fails to return the security deposit, and I've just changed it to say within the timeframes outlined. The landlord forfeits the right, and then if the failure is willful, the landlord is liable for double. So that's just the last change there, just because you have multiple timeframes now, so. Fixing some drafting, okay. Now, we're getting into section 4467, which is the section about termination periods. So sub A, termination for non-payment of rent. Landlord may terminate the tenancy for non-payment of rent shall be, this changes to 10 days. So currently it's 14. In this bill, as introduced, it went down to 7.
And then other bills, it was 3.
Now it's, yep, now it's at 10.
It was partly, there's no magic to any of this, guys. This is partly to shorten the time somewhat, but also to allow, we had testimony that it was really kind of too short. And that there are tenants for whom, for various reasons, it takes them a while to kind of read things, understand things or whatever. And the compromise, which as I remember, kind of popped out of the committee was 10. Okay, go on.
Okay. So then it's the next sentence is the rental agreement shall not terminate if the tenant pays or tenders rent due through the end of the rental period. Added language here to say, provided that a landlord may terminate a tenancy under sub B1 for repeated late payment of rent. Wanting to tie in the fact that those two things are different.
And that's defined later, right?
Yes, sir.
Okay,
So now we're in page 6, so we get to sub B. Okay, so this was somewhat restructured slightly to try to make it more clear what B1 includes. So A is non-payment of rent. B is breach of rental agreement, and if you all recall, under current law, B1 is just the sub I, failure to comply with material terms of the rental agreement or with obligations imposed under the chapter. B2 is where you get into if it's due to criminal activity, illegal activity, other activity that threatens other individuals. So under 1, it keeps the failure of the tenant to comply with the material term that's underlined 6 and 7. And then it just restructures it to say late payment of rent of more than 3 times in a 12-month period. So that's you. Tenant's refusal to allow the landlord or the landlord's agents access to the dwelling unit in accordance with 4460. So it's just referencing back to the section about access. And then that's it. If you recall, as it was introduced, it said that it had those provisions as a kind of a definition of what failure to comply with the material terms meant. And I guess that got a little confusing, maybe for the judiciary. So this is just trying to clarify it a little bit.
Yeah, there's nothing new here from the
If anything,
prior
it's
draft.
just-
It's just
Yeah. And
clarifying.
it's just restructuring it to try to make it clear. So under B1, you may terminate failure to comply with material terms, late payment of rent, which is more than 3 times in a 12-month period, refusal to allow landlord access, and then the landlord shall provide 21 days notice. That's on line 13. And then late payment of rent means payment of rent more than 10 days after rent is due. Okay.
Yeah, Debbie, then Joe.
Oh, I was just gonna say, since we went to 10 days, it's really 15 because of mailing. But are we gonna say how we're gonna count days? I feel like that, are we
Council.
putting that in anywhere, how to count?
How do we know what that means?
So the days count the next day, right? So if it's 21 days prior to the termination date, so termination date is X, I need to count 21 days. The day before is going to be 1. The next day is 2. You have to provide that notice 21 days before them, counting back 21. You raise a good point, though. Keep in mind, if you're mailing, the presumption of receipt is 5, so you need to count another 5 days back. Under the draft, currently it's 3.
So you're serving it on day 1 or on day 0?
So keep in mind, this is
Kind
saying
of backwards here, so
Right.
you know, I kind of backwards, but does that mean that
there is a
on the
termination,
21st day is when I provide notice for?
there is a termination date. You're gonna pick the date.
Yeah.
I want it to be the first day of the month, okay? I have to provide you with notice. That notice has to be 21 days prior to that date. So I have to back up 21 days. Day before that, the 31st day of the month prior or the 30th day of the month prior is day 1. 2, 3, 4, 5, all the way back to 21, okay? That means you have to have actual notice that day. 21 days before the termination date. You have to receive the notice, because remember, the definition requires receipt. So if I'm gonna mail it to you, I get a rebuttable presumption that you received it 3 days after I mailed it.
5.
So you're changing it to 5, but currently 3, so I gotta back up another 3 days. Right? Because you have to receive it 21 days before the termination, and I get a rebuttable presumption that you received it 3 days after I mailed it. So I need to back up that 3 more days.
Okay, let's
Yeah,
go
21.
the other way, just to, I don't fully know that we've answered Debbie's question. Let me do it this
The
way.
day does not count the day that you're mailing it.
Okay. Okay, so I'm gonna give notice by mail. Okay, day 1, I mail the notice. Is that notice presumed effective? I mail it on a Monday. Is that notice deemed effective at close of business on Friday or Saturday?
When did you start?
Monday.
So it's 5
You count
days
the first day.
after you mail it. That does not include the day that you mailed it, after, meaning after the next, right?
Okay, so it would be Saturday.
The following.
It would be Saturday.
Mail it on Monday, the first day you count is gonna be Tuesday.
Tuesday, okay, that's what you wanted to know.
I want it in there because when I asked the court, how do you count days? And it's like, well, then I have to take a time to write a letter to the judge asking him, how are you counting days? And it's
That's
just
reasonable.
wasting court
Do
time.
will you clarify that with these times, the first day is the day after notice was actually given or something? I don't know.
I can try. I get the impression that your judicial system doesn't really care to comply with the statutory requirements as it is, so.
Yes,
Forgive me, because I am, this may be a redundant question, but, what does access to the dwelling unit in accordance with section 4460 of this title mean?
There is a section that says that the tenant has to provide access to a landlord. And they can't withhold consent for the landlord to come into the unit.
but there's time.
No notice?
There's
Sir?
no, there's a time frame. It's 48 hours.
Yes.
And there's, yeah,
I think the only,
and I think there's,
Access says that.
unless it's an emergency, it's all defined.
So it says that the landlord can have access with the tenant's consent, which cannot be unreasonably withheld. So it doesn't have to be 48 hours. If you ask the tenant, can I come in tomorrow? And the tenant says, yeah, sure, come on by, right? The landlord may enter the dwelling unit with 48 hours notice between 9 AM and 9 PM for inspecting the premises, making necessary and agreed repairs, supplying agreed services, or needing to show the unit to a prospective purchaser. So we need the tenant's consent, except for those things. And if it meets one of those things, repair, inspection, showing the unit, et cetera, you have to provide at least 48 hours notice.
Does it say anything about whether it must be the actual landlord or whether it could be an agent of the landlord?
This
Likewise,
section
tenant.
just says the landlord.
Property could be a property, yeah.
I'm just wondering whether it says, but what does it specify? And does it specify tenant or tenant agent?
It just says landlord, and the definition of landlord does not include a landlord's agent. And I assume it just says the tenant's consent, and the tenant doesn't include a agent, I don't believe. It's good that definition.
So in effect, if the person is not the landlord, the tenant may refuse access. Right?
Yes. I mean, under the law, yes, I think you're gonna get I don't know what the value would be if the landlord is having someone come fix a repair. And you say you're not the landlord, you want to access.
Well,
Right.
or the landlord might send their, son who
Yes,
you didn't agree to be alone in the apartment.
yes.
I think I'm okay.
Are you sure?
Yeah, I
Do you think that would be a good idea to define it? Like,
I don't think it would hurt, because this section on termination says landlord or the landlord's agent, so.
Unless you want to define landlord to include the landlord's agent.
You have a section for access. This section for termination is going to say if you don't give the landlord's agent access in accordance with that section, then you can't be terminated. So
right, and like if we're gonna specify that, then my feeling is that we should also allow a tenant to have an agent.
I think if we said, I think if the tenant sends the landlord a note, says, so-and-so is my friend and I'm out of town and, you should contact him. They can do that. You can always appoint an agent unless
But
it's
it's,
prohibited.
But this is giving, so isn't this just giving permission to enter? The
Yeah,
tenant may or
that's all.
doesn't have to be there at all.
There was a request that I also mentioned that a landlord can gain access to the building if there's a reasonable belief of imminent danger to the property or
Isn't that in the,
that's in the access section.
that's in the other section? Okay. All right, so we're, okay,
So you have me potentially adding a clarification about days.
okay.
I will take a look. Yeah.
Okay.
I have one question just for compatibility reasons. That it's a non-payment of rent is 10 days and a non-payment of rent is 21 days.
Non-payment of rent is in sub A. If you do not pay rent, then it's 10
Oh,
days would be the proposed termination notice period. Under the sub B1 is for repeated late payment of
repeatedly.
rent,
Okay,
which would be
so
20 days.
repeatedly.
Well, this came from when we were sitting down talking. This was actually the law as it is now. It's kind of vague and not very clear. And so this clarifies it.
I think it looks okay.
Maybe it's, I don't know, just seems,
In other words,
so if you just don't pay rent, 10 days.
if late payment of rent is defined as not having paid within 10 days.
Okay,
One. Second, repeated late payment of rent is grounds for termination. So that means if someone repeatedly isn't paying rent
Right.
for 11
11.
days, they can be evicted.
Your vice chair's question.
Yes.
I just wanted to clarify something. So what you're saying is like, no matter what the lease says, like if we say the rent is due on the first and there's no grace period, you're
Really
putting
due
a
on the
grace
10th.
period in?
We are.
What do we do on the tenth?
It's not putting a grace period in, it's clarifying what you can terminate due to a late payment of rent.
And it was vague before.
In other words, you can say your rent is due on the first, okay? And it is due on the first as a contractual matter,
Right.
okay? But what we're saying is if you're gonna then turn around and evict them, you can't evict them for paying on the second. You can, you evict them, but you can't evict someone for being a day late.
What if somebody is notoriously 9 days late?
Yeah.
Every single one.
Months of the year. Still a
So
problem.
I will also comment that in A, you can't terminate if the tenant pays or tenders rent due to the end of a rental period in which the payment is
And
made.
that's
tendered.
existing law,
So
which we didn't, and there was no exception for this situation of repeated, like,
Sorry, what, Cameron?
I was just gonna say, if rent's due on the first.
Yep,
Somebody doesn't pay you by the 8th.
Yep.
Then you go to terminate them and they pay you on the 9th, can't terminate the rental agreement at that point. So my understanding is this was added to say, notwithstanding that, if you continue to pay late, the habitual late payment tenant, then we're going to give the opportunity to terminate based on that. So then naturally, well, what's the definition of late?
right.
And you settled on 10, you all could say 5. You could.
yeah, it's up to you. It just was, our thought was, it was better to say something than just say late payment.
Because right now, the status quo doesn't have that clarity.
No, it does not.
So we want that clarity, and the decision is how many days.
Right.
And I think it looks fine the way it is.
I do too.
That's 2 people. And the chair. I think that's fine. 3 in the chair.
Okay, I'll tell you what, we're
We're
gonna
not
leave,
hearing anybody.
I'm
Any
gonna
objection?
circle this. Yeah, I'm circling this as an issue.
Oh,
I'm just gonna, we're gonna move, yeah, but there's lack of. There's people who are a little worried about the 9-day renter.
I was just asking.
Yeah, well, so we'll come back to it.
But so the second section creates an area where the person 9 days late 3 times now becomes in violation.
But nothing's ever gonna be perfect.
Oh, I know.
Always- No, no, I understand.
I'm not trying to change, I'm just trying to make sure I understand.
Yeah,
what
I'm
it's
just
doing.
saying, like, there are
Not that it's
gonna
wrong.
be issues with everything, but right now, it's still more defined, right now, it's complete nothing.
Yeah, right now, the law, it's really weird. It in terms of giving you a way out of the continuing late payment person, it's very vague. This is an attempt to clarify that. I think we should come back to it. In other words, is it 10 days? Or
No, I'm not worried about the days number. I'm just making sure that the person who's in that scenario of, if we change it to 10 days, the person who's late 9 day, or, you know, paid on day
It
9,
keeps doing a
they have to
9-day
get-
thing.
evicted or sent an eviction notice and then they pay it 3 times? Do they have to create that record? So you have to just keep sending them an eviction letter every time they're 2 days late so that they can pay within 10 days. And now it's recorded as a late payment. And now you have 3 of those in a 12-month period. Is that?
The current statute says you can terminate a rental agreement due to failure to comply with a material term. The separate section says that you do not have to demand payment of rent. It's due when it's agreed upon and the landlord is not required to demand it. If the landlord if the landlord wants to, they could pursue an ejectment and a termination based on your continued late payment of rent now, under statute. I would argue your 9-day late renter is failing to comply with material terms of the rental agreement. So I don't know that you need statutory language to accomplish that goal. If you want to include language to clarify that this is included, then you need to define what late payment of rent means. So
And we did.
I think
Part of the problem we're dealing with is that later on, let's say you evict someone. I mean, you file an ejectment action, and then they can pay rent into court. They can pay rent up till the last minute. And then where are you? It sort of defeats your ejectment act. But by putting in repeated late payment and defining it, that's grounds for saying, no, that's not enough. You know, they've been constantly doing this, so they're gone.
And so I've got hoping to answer the question, Brett Parsons. So like I interpret it now is, what does your lease agreement say? And if it says rent is late as of X day, then you as the landlord would have to follow that as well. You'd be able to terminate them for continuing to pay late if they're not paying. But
So is the question on the table to, we're gonna hold it
And we're
and
gonna leave it as it.
as is, and then, okay.
I just might come back to that.
Yep.
I'm just
The age
indicating,
part.
yeah, I'm just coming back to it where people are expressing.
Any sort of.
Yeah, any sort of, well, I'm not sure. Okay, there's something important coming up. We have 15 minutes left. Go for it.
okay, so now in the subsection 2, so this is also for termination for breach of rental agreement. And the change here is to remove reference
That's
to
coming up.
activity, illegal drug activity. So when termination is based on criminal activity, illegal drug activity, acts of violence, damage to the dwelling unit, etc. That was in the draft as it was introduced, but it's being proposed to be.
This came at your request. This came at the request of the committee. The consensus of the committee was, let's not focus on criminal activity because it or even use that term because or illegal because it implies that people have to be arrested, or it gets us into the whole criminal law thing. And we just decided, look, violence and damage or any other activity which, and this is the key, threatens the health or safety of the other tenants, the landlord or the landlord's agent or neighbors. And then we don't need to get into criminal activity and illegal. I mean, it obviously includes it.
I think that's that.
There was a proposal, Mr. Chair, or you suggested possibly clarifying this to make sure it was the
Oh, right.
tenants. The tenant's act of violence or damage. Currently, it just says acts of violence, damage to the dwelling unit or other activity.
I was just gonna propose that, and I was just gonna say not only the tenants, but
Yeah.
their perpetuation of it, because if it's a domestic violence situation and they are a victim, I wouldn't want them to be evicted because they were being abused in their home. Because
We do
violence-
have
so
criminal.
that- We do have protections for that.
We think, well, wait, this is really important. What about, what was worrying me, and it's clearly worrying you, is what happens when somebody really is a victim? You know, they are, a drug dealer has come in and just say, you're letting me sell drugs here, kiddo. Or I'll give you some drugs in return, but you know, you're letting me sell drugs. How are we going to deal with that? And the answer, the way we deal with that is through an enhanced trespass requirement, which we'll get to. In other words, the landlord, if it's the tenant that is causing the violence, the problem, the drug dealing, this section lets them evict them. If it's an invitee, it's an involuntary invitee, we have enhanced trespass coming up.
But if it's two tenants residing in a place, and one of the tenants.
And you know, I don't know how you deal with
So I
that.
Yeah,
talked
kind
to
of
the
thing.
network about that. Is that kind of where you're
Yes.
going? So I did talk to the network about that, and they sent us a memo with their opinion on that, because that is absolutely not an intention that I would want to have anything to do with in this bill.
Do they have proposed language?
It's we can pull up the memo.
But I mean, should we give it to him to come back with?
Yeah.
He has it, he said.
Okay, he's got it. All right.
So yeah, I think speak for many in the committee that we want to make sure that folks in that situation are absolutely not penalized in this bill, that it would be horrific to me.
I think we'll have to see the language. And I don't want to complexify this to the point where it can't be used, so.
Yeah.
But I agree. Thank you for.
So what would the witness name be under?
It was from
The network.
Charlie Glisserman from the Vermont Network sent in their opinion
Okay.
and talked to them about it.
Go on, because, yeah, I'm sorry.
Do we have anything, I'm just, I just out of curiosity, because you're more familiar with this area of law than I am. But is there anything currently which allows a tenant to break a lease if the landlord does act in a way that's inappropriate or violent towards the tenant?
There is a separate subdivision in this chapter related to domestic abuse circumstances. So let me review it and circle back.
Okay, thank you.
Okay.
Debbie, have you-
I'm gonna put-
Could they give restraint?
Well, if you have a restraining order against your landlord, then how do you square that with access to the?
Well,
Right.
if we have an agent can have access. You're saying the landlord's creepy. And so like you don't want them around or whatever, you get a restraining order. And then an agent can go for access.
Or tenant has the right to break lease in that. All right.
All right.
Okay, that too, should have mentioned it earlier, the proposal here is for the termination notice period to be 5 days. It was 3 days as it was introduced and it's proposed 5 now.
This is zone A.
The
Concession.
zoning. Consent.
Yes.
Okay,
Yep.
2 more pieces here under this subsection. B would require the actual notice required under the sub B. So this is if you're terminating because of failure to comply with the material terms, repeat late payment of rent, not allowing access, or to the threats of violence against the landlord, other, neighbors, other tenants. If it's terminating for one of those reasons in B, The actual notice shall be accompanied by an affidavit setting forth particular facts and the basis thereof in support of the termination with sufficient details to inform the tenant of the reasoning behind the termination. Sub 3 is added here. This is new language that was not in the bill as introduced. The landlord shall not terminate a rental agreement under this subsection based on a person seeking medical assistance for a drug overdose, being the subject of a good faith request for medical assistance, or being at the scene of a drug overdose or within close proximity of the scene of a drug overdose as provided in 18 VSA 4.54. Evidence obtained from the good faith request for medical assistance for a drug overdose shall not be used in an ejectment action brought under 12 VSA chapter 169.
So, oh, sorry.
I was just gonna say, so 18 VSA 4254 is the section that provides immunity, certain criminal immunity for individuals who are needing medical assistance or have asked for medical assistance for someone else due to a drug overdose or at the location of a drug overdose when they seek medical assistance. I can pull that up, but I would defer to one of my colleagues for any specific questions on those provisions.
I just want to say that this addition is really important to me. That it stays in and was an error years ago, not having this in our Good Samaritan law. And so, I would advocate that this piece is very important, to the bill and that,
This is the Good Samaritan situation. I mean, we don't want to discourage people from dialing 911, it's recorded,
Right.
et cetera. And so that's what this is. Partly, one reason why I felt comfortable with this is, as you remember, throwing someone out, evicting them because of actions which threaten the health and safety of other tenants. Somebody who unfortunately is addicted to drugs and sits alone in their place and, does whatever they're doing, it's not aimed at them. They are just, they're not endangering necessarily the health and safety of other tenants. But
I don't,
so
right.
if something happens to them, I want people to come in
Mhm.
and be able to do this and not like, oh my God, I've just provided.
I don't want someone choosing between saving someone's life and the fear of eviction. And
Okay.
that's why this
That's
is
what
in
this
here.
is.
Sense.
Okay, what's next?
Okay, now we have sub C. This would be changing it to cover basis of termination for tenant or government notice to vacate. There's no changes from the bill as introduced. So it's just a rewrite of this section. So it covers where termination is based on the intent to vacate provided by actual notice from the tenant. The landlord can terminate the rental agreement on the date provided in the notice. And then the second piece here is about when it's needed for compliance with the government agency or government order, set of changes. So then we get to sub D, where it's termination of the rental agreement when the property is sold or repurposed. So a few changes here. First off, it's gone from 30 to 90 days. And then I've just included some language here. So it's whether there is a written rental agreement or not. But if there is a written rental agreement, it's still, you have to 90 days before the end of the written rental agreement. So you still have to wait out the written rental agreement in this situation.
Let me
So,
ask a question.
Yes,
Say a landlord has an extenuating circumstance, family member sick, they have to sell their property. They can sell, but they can't repurpose until 90 days after the agreement.
after notice.
if they go to sell the building.
Yep.
And they're part of the contract for the sale is that there be no tenants in the building.
Yeah,
Then they would have to provide 90 days notice for the individuals in the building to terminate the agreement
If
before they
they,
would sell in that instance.
or if they are willing to leave the tenant in the building,
The new,
then they don't give any notice.
right, the person purchasing the property may say, I want to be a landlord and leave the people that are there. In the situation that you did identify, if you are in need of a family member to, need of, a place, a dwelling unit for a family member, you would have to provide 90 days notice if there's no written rental agreement. If there is a written rental agreement, you would have to provide 90 days notice for the expiration of that to terminate.
Okay, go on. We have
Okay,
whatever you want to say in the next 2 minutes.
I'm gonna take you down a rabbit hole that it may be worth pausing. Here's here's what I was describing to you yesterday. He says if you're gonna terminate because of repurposing the property, so it includes you contract to sell the building, it's necessary for a member of your family to occupy the premises, you're permanently withdrawing the unit from the market, you're demolishing or renovating the unit. Then you get to subsection E, which says termination at the expiration of the rental agreement, and it makes it 90 days. So if you don't have a written agreement, you have to give someone 90 days. If you all recall, based on this cheat sheet, it's different period depending on if you've been there for 2 years or longer, 60 days, greater than 2 years, 90 days. Okay. What this proposal does is it makes all of those things 90. So there's no longer a distinction between 2 years or less, greater than 2 years, etc. It's just 90 across the board. If that is the case, that it's 90 across the board, I don't think you need this individual subdivision.
Right. You know.
Right.
Let me explain something for the committee.
It says a renal agreement, not rental agreement.
Okay, since we're out of time, I just want to leave you all with the rationale here.
Good catch.
I thought about this a lot, and I realized one of our goals is to simplify this whole damn thing. And it had all these different notice periods, and there was less than 2 years and more than 2 years, and for this and for that. And I just thought, yeah, it's true, you're rewarding people to stay longer, but to me, that seemed arbitrary enough that I finally just said to Cameron, will you just make it 90 days front? So this only applies to situations that are in the landlord's control. Okay, that is termination because they want to put their family there. They want to sell the building. They want to condominiumize it. They just want to end the lease. It's all about them. In that case, they can plan and they can give the 90 days. And that's something very important that we are giving tenants, which is in this terrible market where there's almost nothing available, we're at least giving them 3 months notice to price. Yes.
I know we haven't gotten there. I was just kind of skipping ahead, but I would like us to think about just as a technicality. Just as a technical change, adding somebody in addition to the county sheriff or the county sheriff's office to be able to execute an eviction notice.
We'll talk about that.
I know.
Okay, but we actually,
Just a good point.
that's a good point. Okay, noted. County sheriff, we have to discuss that. All right, thank you.
Great.
Now, what we're gonna do is take this up again on Wednesday, tomorrow at 11 o'clock.
More markup, more discussion.
Right, and you know what, everybody, I'm teasing you all at becoming super intense. But
Yeah.
actually, I think this is something we all gotta do.
It's a very serious matter.
The
As much
committee
as I
is being
go.
serious, and I think
very
it's really true. I'm all teasing aside about pseudo lawyers, I mean, in this group.
I don't think any law school.
Okay, so next, we're gonna take a 13-minute break, and at 3:15, we're gonna take H 887 with an introduction by our ranking member and Sophie Satney taking us on a walkthrough.
Not 12 minutes, 13 minutes.
Right. Thank you, everyone, and thank you for those of you who attended and contributed.